Kamini is the drug which is manufactured by one, is poured into another bottle to send it to Australia. Chemist, Ayurveda chemist, and get it. It's available in open market without prescription. This is also very important. But since Australian government has banned its import, this was put into other bottle and labeled as Hajmola. Now, if it is an offense, it's the first offense against the producer, manufacturer. But that would not justify that this contains narcotic drug. And there also, I may have 1,000 transactions with the person in Australia. I am not disputing, I am with my friend. Yes, prejudice. But that is, every prosecuting agency would say that there is no prejudice. Every accused would say that heavens are going to fall. It's ultimately for your lordships to decide. There is a drug called Kamini.
Yes.
There is a drug called Kamini.
Yes.
Now, it is on record. I am just putting it for my lord. And I will not take long, my lord. I will not be a stumbling block.
No, you may take your own time.
Only thing is, trial will get over.
Yeah, I am aware. So, no problem. Yes.
Because, my lord, the instructions are, learned trial judge is of the opinion that even if she has to sit up to 10 o'clock at night, she would sit but finish off, because there is a direction of the Supreme Court.
Yes, what is the
And
just tell me.
Now, Kamini is the drug which is manufactured by one Multani Pharmaceuticals Ayurveda under license. I will concede, my lord, that if at all there is an offense under Drugs and Cosmetic Acts, NDPS doesn't come into picture.
Yes.
Now, this Kamini is a licensed drug available for sale in open market. And there, Government of India has issued license. So, NCB can't be wiser than Government of India, because that is a permitted drug. Now, its components, my lord, I have given to your lordships. This is the ingredients. First page, my lord.
Yes, yes.
Come to the second page. Ifen derived from opium is included for its potential pain relieving properties and may play a role in relaxation. So, there is no dispute by anybody that this is used, and it is used under license of government issued by ministry. Now, the case is, and that is all. Case is that this was ordered to be brought to my place by courier. NCB followed it up at the courier's place and then called us. Then came to our factory. It is found that it is Kamini packed, which is very important, because that is available only. One can go to any chemist, Ayurveda chemist, and get it. It's available in open market without prescription. This is also very important. So far, no difficulties. Now, the case of NCB is, which may be an offense at this stage. I will not request your lordships or pray that weigh the evidence in golden scale. That's not permissible. The case is that those bottles of Kamini drug, same, no addition, no subtraction, was put into another bottle, and it was labeled as Hajmola.
Labeled as
Hajmola.
Hajmola.
Not for sale in India, because India, anybody can take Kamini. But it was sent to Australia. Now, there is no material coming forward that this was, earlier part stands approved, that it was found in a bottle labeled as Hajmola. But for sending it to Australia, accepting my confessional statement, there is nothing. No material. Absolutely no material accepting my confessional state. But assuming without admitting that this was to be sent to Australia. It is no offense, possibly from the reply that I hurriedly went through. Somewhere, some line I found that in Australia, this drug is prohibited. In Australia. If your lordships can give me 15 seconds, because very hurriedly outside.
6.4 paragraph.
In para, yes, para 6.4.
Last director of my reply is that document also of
Yes.
Australian
My lord, I'm not disputing. My lord, normally when an affidavit is filed coming from government agency on facts, normally, sometimes we have to, but normally we don't. Why should officer lie before the High Court? They may lie, they may implicate me, that's outside the court. Now, my lord, short point is, your lordships have seen the definition of hyphen.
Yes, I have seen.
So this is permitted. Now, my lord, I'll show your lordships the statutory provision. One page number 15. Main matter. Opium derivative, my lord, is not a narcotic drug. Under the Act also. And that has not been the case of a, my lord, narcotic bureau also. Come to page 15. Definition clause section 2, Roman 16.
Yes.
Small 16. Opium derivative means medical opium, that is opium which has undergone the process necessary. No, there is no dispute. E is relevant. Because they have also not challenged it. All preparation containing more than 0.2% of morphine or containing so and so. I am 4. This company has a license of 4. What is found is also 4.
Yes.
Possibly what my friend on the other day meant was it is more. It has to be more. Statutorily, it is banned if it is less than 0.2. All preparations containing more than 0.2% of morphine or containing any so and so morphine. Diacetyl morphine. And their FSL report is 331, 3.31.
Page number 330.
At page 331,
2.4.
2.4 is the percentage. Please come to 331. Report. My lords got it?
Yes.
The sample is in form of dark brownish pills. On the basis of chemical, chromatographic and spectroscopic examinations, it is concluded that sample under reference answers the positive test of opium. And then please come to last. Morphine is 2.4. It has to be more than 0.2. So here it has to be more than 0.2. Less than 0.2 is opium, because this gets diluted with other. So here the counting of opium is not in terms of other narcotic. Lesser it is grave. It is dangerous. More it is, and this is all statutory, my lord, governed principles and provisions. So NCB can't be wiser than what is prescribed. If prescribed is less than 0.2, then it is opium. If it is more than 0.2, it is, my lord, not an opium. Derivative opium is well defined. So far as ABCD is concerned, there is no dispute. E, I am showing to your lordships their own affidavit, their own report of FS. Now, my lord, comes the question, last question, to which possibly I have no escape route. And that is mislabeling. But mislabel is an offence under Drugs and Cosmetic Act. There will be hail of a difference. Your lordships are much more aware than me. My lord, an accused of NDPS, an accused for violation of provisions of Drugs and Cosmetic Acts. Not the first eventuality, court will look at the jealous eyes. Court will definitely look with a jealous eyes at an accused who is charged with NDPS, and will have a different spectacle to look at, my lord, an accused under Drugs and Cosmetics Act. Now, my lord, kindly turn to the definition of misbranded drug. કઈ book છે આ?
Drugs and cosmetic index.
આપણે
Memo માં present છે.
Page 21 of the memo. And kindly come to
Yes.
the next page, section 33E. My lords got it? Page 22, 21.
Yes, 33.
Misbranded drugs. For the purpose of this chapter, an Ayurvedic, Siddha or Unani drug shall be deemed to be misbranded. We are concerned with Ayurveda.
Yes.
Color coating is not the problem. B. If it is not labeled in the prescribed manner. So that manner is changed. So what has actually happened is that your lordship other day had shown that
Yes, yes,
Drug.
that too. Yes.
the case is that we used to open it, and as it is used to put it in another bottle, and that bottle we used to seal it and label it as Hajmola, and we used to send it to Australia. Now pardon me for repetition, one line. There is nothing on record that it was to be sent to Australia except my confessional statement. And secondly, that it was branded as Hajmola, which will be an offence under 33E, will not be an offence under NDPS, unless I have added something. Now, if it is an offence, it's a first offence against the producer, manufacturer, whom you have given a clean sheet. Your own case is that that very drug, very medicine is poured into another bottle to send it to Australia. And since this was done because this drug Kamini is banned in Australia because of its derivative, containment of derivative opium. I have done something wrong, but not as wrong as it is projected. For the time being, I am conceding, not that it is my concession, but
Yes, yes.
limitations of 528, my lord, can't go beyond that. Therefore, my lord, there is absolutely no case, nothing is found. Derivative opium is found as per laboratory test to be 2.4. It has to be above 0.2. Therefore, there is no case, my lord, of narcotic. And very fairly, my lord, I must say, in the reply also, nothing beyond that what I have argued is. And lastly, we have questioned, if your lordship comes to my averments,
Yes.
if it is, my lord, page 27, then the process falls. But this is an alternative. I stick to that. There is no violation of, my lord, NDPS Act. But too much. Para K.
Yes.
The petitioner most respectfully submits that entire investigation carried out in connection with the seizure of the aforesaid consignment also seems to be colored with malice, solely determined to implicate the petitioner herein in one way or the other. The same can be inferred from the fact that although the DHL courier had been intercepted and that parcel contained all details of the sender, there is herein deemed it fit to carry out procedure of spot testing and seizure in absence of the aforesaid individual. Furthermore, this is important, the details of Panchnama prepared at the time of carrying out seizure operation of Shah Exim also suffers from discrepancies, wherein NCB team including investigating officer is shown to be arriving at the warehouse in Bolero car, whereas the fact of the matter is that NCB team firstly arrived at the warehouse location in petitioner's private, in my vehicle, and thereafter drug testing kits and requisite inventory used in the seizure operation was deboarded from another private vehicle arrived at the location. It also remains unclear as to how the spot testing of the substances present in 40 jars at DHL office and 12 jars seized from warehouse reveal positive results for opium in the first instance and had thereafter rendered a finding of not testing positive for containing any violating narco. What I want to convey is when they carried out, they found.
These are the questions you would have to ask to the witness in the cross examinations. These are the defenses.
I would
In the
feel,
crossing petitions, those
I would feel so. But my lord, then I will not argue. I will just put two judgments for your lordship's perusal. That this has to be done in presence of the magistrate. 52A statutory provision no longer
Claim is done.
magistrate was present.
Yes,
What they did was 52A says in presence of the magistrate. Just have a look at 52A.
NDP, sir.
And then two judgments which says that it is a piece of paper. But I must tell your lordships, the subsequent judgment takes the view that this will not be applicable in deciding bail. But I am not in bail. All three judgments are. So that I may not be accused of suppression.
Yes, yes.
Bail, they say that even if it is not there, court will have to consider bail on the material available. This point of 52A will be available, will not be available for decision making process of bail. Please see, disposal of seized narcotic, drug and psychotropic substances. The central government may, having regard to hazardous nature, vulnerability of theft, substitution, constraint of proper storage space or any other relevant consideration, in respect of narcotic, drug, psychotropic substances, controlled substances, or conveyancing by notification, specify such narcotic drug. But we are not concerned with this. 2. Where any narcotic, drug, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53, the officer referred to in subsection 1 shall prepare an inventory of such so and so containing such details relating to description, quality, quantity, mode of packing, marks, numbers of such other identifying particulars of narcotic so and so, or packing with their packed country of origin, other so and so. Then, my lord, allowing to draw representative samples of such drugs or substances in presence of such magistrate and certifying correctness of any list of samples or, the purpose is when an application is made, the magistrate shall, as soon as may be, allow the application. Now, why this? Because where there are stringent provisions of bail, liberty is put at jeopardy. Parliament at the same time wants to prevent its misuse. Therefore, at the stage before you send it to laboratory, magistrate's role has been incorporated. You can't do anything. My friend has to show that all this has been done. What has been done is magistrate is informed. Information is not at all relevant. You have to make an application which magistrate is forthwith bound to allow and accompany. You cannot do because A and B may see. He has to certify the correctness of inventory and he has to certify in his presence, photographs have to be taken, and he has to certify it as true. Now, in this case, simply magistrate has been informed. Photographs have been taken, packets have, but magistrate was not physically present. And this, my lord, nullifies everything. There are two judgments. I'll give the citation. I'll put the
So
copies
section-
also.
Provisions of section 52A have not been complied with in true sense.
Yes,
And
no,
that is why-
judgments, not only statutory provisions. They are no longer,
Mandatory in nature.
they are mandatory in nature, but they no longer remain only statutory provision. They are now interpreted by Supreme Court.
Yes.
Yes, and that છેલ્લા બે આયા ને જસ્ટિસ અભય ઓકનું અને જસ્ટિસ ગવાઈ. No, Mohanlal is now an old law, but the recent two judgments, Mohanlal is by 3 judges bench. But I'll give all 3 judgments plus the last judgment which says that bail can be decided.
Yes.
So my friend may not be
Independent
aware.
Bill can be
but-
decided without entering
Yes.
into the error.
Lord,
of this.
the reason is my friend may not be aware, but I must, as an officer of the court, put it to the notice of the court that Delhi High Court's judgment, while this was not followed, released the accused on bail. Supreme Court said that these are the provisions not applicable to bail. So even if my friend doesn't know, if I know, I must bring it to your lordship's notice. These 4 judgments, my lord, I will put it. Mohanlal, then recent 2 judgments. I don't know, serious prejudice. But that is every prosecuting agency would say that there is no prejudice. Every accused would say that heavens are going to fall. It's ultimately for your lordships to decide.